Another very important hot topic, fresh off the press, Nevada Supreme Court just came up with a new case law. Case under Anderson v. 8th Judicial District Court, State of Nevada, in and for the County of Clark and the City of Las Vegas. Now, some people say the Supreme Court moves slow. Cases came out literally yesterday, September 12th, right here, big headline news. Because guess what? Now you got to have a jury, because it used to be under Nevada case law that you did not have a requirement for a jury trial on domestic violence cases. In Nevada, you're not allowed to have a jury trial on any misdemeanor. So what happened was a case called AMEZCUA went to the Nevada Supreme Court a few years ago. And what the Nevada Supreme Court said was, and actually I took the wrong page, it says that because losing your gun rights, which is a Second Amendment, a substantial right, a substantive right, and a constitutional right, is that you are now facing a federal regulation, not a state law. So therefore, you're not losing your gun rights because of a Nevada law. But guess what the legislature did? They went out and they passed Nevada Revised Statute 202.360, a statute that prohibits the possession or control of firearms by certain persons, was amended, quote, has been convicted in this state or any other state of a misdemeanor crime of domestic violence as defined in 18 U.S.C. Section 921, subsection A, subsection 33. So in our opinion, this new penalty, a prohibition on the right to bear arms as guaranteed by both the United States and Nevada constitutions, clearly reflects a legislative determination that the offense of misdemeanor domestic violence is a serious one, and therefore overturning a Nevada case that actually went all the way to the Supreme Court of the United States in 1989. It was called Blanton versus North Las Vegas. Blanton versus North Las Vegas stated, misdemeanors are petty offenses. Maximum punishment is 6 months in jail, $1,000 fine, community service, blah, blah, blah. So, you do not have the right to have a jury trial. The Nevada Constitution and Nevada legislature passed the law. Domestic violence cases now have the right to have a jury trial. Now, practically speaking, I've talked to my friends in the court system. They put 2 departments in charge of domestic violence cases. Each one of those have usually a minimum of 10 trials scheduled Monday, Tuesday, Wednesday, Thursday. So guess what? Where are you going to put all these jurors? What are you going to go forward? What are you going to do? Practically speaking, this is a nightmare for all these courts now. Well, that's a good question, but here's the answer. The first offense is a misdemeanor. Because what happens if somebody pushes another person and they're dating or they're married?
Or they're roommates.
Well, or technically roommates. Does that deserve a felony? You know, you push somebody, there's no physical injury, nobody's hurt. Technically, that's a battery domestic violence. I don't think that deserves to be a felony. So what happens is, first offense is a misdemeanor. A second offense within 7 years in Nevada is still a misdemeanor, but it has a higher minimum punishment. 3 domestic violence convictions within a 7-year period results in mandatory 1 year in prison. Now also, if you beat somebody up and you hurt them, substantial bodily harm, even if it is a first offense, you jump right into the wonderful world of felonies. And then eventually you do get a jury trial. Correct, and that happens all day long. There's tons of people that get arrested, they have a little red mark on their face. Does that deserve a felony? My opinion is no. I'm not approving of touching another person. That's not appropriate. I'm not agreeing with that. That's why if you get convicted of a domestic violence first offense, 6 months of domestic violence counseling is minimum. 1.5 hours per week for 6 months, but not more than 12 months. An alcohol evaluation, minimum fine is $345, 48 hours of community service. That's the minimum sentence, and a maximum of 6 months in jail. So to answer the question also, about the petty offense. A petty offense is a misdemeanor. So once again, as we were talking about earlier, soliciting prostitution, misdemeanor. However, soliciting a minor, felony. So there's different distinguishing factors that are within the law. So what happens now also is when you have a jury trial, you're at the Regional Justice Center, which is downtown, the big tall pink building with a little arch on it. There's jury services. Currently, the Henderson Justice Court and Henderson Municipal Court, both housed in on Water Street. North Las Vegas Municipal Court off of Cary, that's North Las Vegas Justice Court, and North Las Vegas Community Court off of Las Vegas Boulevard, they do not have jury services. Where are they going to get their jurors from? Right now, all these courts are scrambling to comply with this new law. But the law doesn't worry about the practicalities. They worry about what is right and what is justice. Once again, justice is blind. But me as a good defense attorney, I'm only blind in one eye, so I like to peek, make sure I do the best for my clients. That's a whole nother story. The alternative is, or was, a bench trial, meaning you present the case to the judge. The judge sitting at the bench makes a determination of guilt or innocence. So that's what happens. But it depends. Because here's the thing. It depends on who your judge is. A conservative judge isn't going to buy the nonsense. Now, when I was a justice of the peace and I had a case with no physical injuries apparent, there was pictures taken, police officers wrote, I could not see any visible injuries. They did not complain of any visible injuries, and both people are drunk. At the scene of the crime, both people are drunk. Defendant says, I didn't touch her or him. Victim says, that drunken fool hit me. And they're drunk. And they cart the defendant off, and off to jail he goes. And next thing you know, we're having a bench trial when I was a judge. Now we get victim under oath. And the victim under oath is sober. And there's no corroborating evidence, meaning nobody else saw this event. So there's no independent witnesses or third witness. It's victim and defendant. You also don't have any corroborating evidence in a physical showing of an injury. For example, if victim says defendant slapped me and there's a red mark across the person's cheek, that's corroborating evidence. But when there's no evidence and you got a sober person under oath, subject to cross-examination and no corroboration, I'd find that person not guilty. I would also say, look, morally, we know what's going on here. Something happened that night, but legally, we just can't prove it, Mason. So, that would be my point of view. Believe me, I've been in front of judges where they say, we don't care that you were drunk and not under oath. You're telling the truth then, and that's what a lot of victim advocates state. The victim advocates will say, they're telling the truth. And therefore, now they're back, they made up with their boyfriend or girlfriend, and now they don't want the person to get in trouble, and it's a cycle of domestic violence. And in some cases, absolutely, I agree, that is 100% true. But I don't know what a jury's gonna do. They might read through it and say, hey, this is a bunch of crap. They're telling the truth when they were all liquored up and that way. Or two, they might say, look, guilt beyond a reasonable doubt. You've got to prove this case guilt beyond a reasonable doubt. And they might make a decision like I said when I was a JP. Hey, something happened. You just, Mr. Prosecutor or Miss Prosecutor, cannot prove it. And that's guilt beyond a reasonable doubt. It's going to be interesting.
Do you have to get a jury trial, or can you still ask for a bench?
You have to. My understanding is you're going to have to. Well, actually, criminal cases you don't have to demand it; it's automatic. Civil cases you have to make a demand for a jury trial, and there's a bond fee, and there's all kinds of fees, and money's got to be paid. And civil cases you make that request. Criminal cases it's automatic. So this is going to be quite interesting to say the least.
TheVegasLawyers.com. Lawyer up.